Good morning to all of you. This is Dr. Pallavi Gupta. Today I will discuss on informed consent. I will discuss on various issues. For example, introduction of the informed consent, background, the criteria of doctrine of informed consent, significance of informed consent, meaning and component of informed consent as a patient right, several issues related to the informed consent, several case laws where the informed consent is missing, and the guideline of the Supreme Court with respect to informed consent. Regarding informed consent, Russell Jones said that informed consent is voluntary agreement by a patient to a proposed healthcare management. It is an approach of healthcare management which is given after proper and adequate information is conveyed to the patient about the proposed management, including potential risks and benefits and alternative management options. We can say informed consent is the part of express consent, which is written well. And this consent has to be taken by healthcare provider or medical practitioner from the patient at the time of medical treatment. There are several approaches regarding the background or the doctrine of informed consent. Let us take the first one, approaches of English Court, American Court, Canadian Court, and at last Indian Court. What is the approach of Indian Court? Regarding the approach of English Court, it says that English law recognizes the duty of doctor to warn his patient of the risk inherent in the treatment which he proposing, specifically if the treatment is surgery. The clinical limitation is that the duty is confined to material risk only, meaning thereby it is the duty of the doctor to take care, and this duty is towards the patient. When patient come to the doctor, it is the duty of the doctor to inform about the risk which is inherent in the treatment. But as per the English law, it says that doctor may inform about the important risk or material risk which is involved. Regarding the American approach of American court, the US court in several cases observed the question whether or not the omission to warn constitute a breach of doctor's duty of care towards his patient. It has to be determined not exclusively by a reference to the current state of responsible and competent professional opinion and practice at the time, but by the court view whether the doctor in advising his patient gave consideration which the law require him to give the right of the patient or make up his mind in the light of the relevant information whether or not he will accept the proposed treatment. Meaning thereby, as per the American code, where was the question, the omission to warn constitute a breach of duty or not? Duty of the doctor towards the patient. And this duty, this question will be determined not only by the state of responsible and competent professional or their practice, but it will be determined by the view of the court. Whether patient was advised by the doctor and several consideration, patient has decided whether he has to opt the treatment or not. It has to be judged by American court. Therefore, a consensus made adult patient of sound mind is entitled to decide for himself whether or not he will submit to a particular course of treatment proposed by doctor. This entitlement is foundation of the doctrine of informed consent, which originated in USA. This concept favored by the doctrine of the informed consent is basically originated by American court, and it is favored by the uh, court of Canada as well. The North American concept of informed consent implies an objective test of a doctor's duty to advise the patient of the advantage and disadvantages of the undergoing the treatment proposed, and more particularly to advise the patient of the risk involved. Meaning thereby doctor has to advise the patient about the advantage and disadvantage which is inherent in a particular treatment. As in the case of Canterbury versus Span, this is a very important case. It is said that this doctrine of informed consent has been originated in this case only after the Bolan case. It was held that the question of disclosure of risk tested by the tenets of the accepted practices may vary from patient to patient. A risk is material when reasonable person would be likely to attach significance to the risk whether or not to undergo the proposed therapy. The disclosure is essential when the course of treatment being recommended will inevitably produce damaging side effects and when medical experiment is being proposed on a healthy volunteer. Meaning thereby if there is some damage is involved, there is some side effect is involved, it is the duty of the doctor to inform about all those risks to the patient. As in the case of Relvi versus Hughes, in this case, a neurosurgeon formed the opinion that his patient required surgery in order to clear blocked artery and to prevent the stroke in the later part of life. The patient was kept in complete ignorance of the high risk involved in the operation. The patient was paralyzed by stroke suffered during the surgery. The surgeon was held negligent for the failure to obtain proper consent from the plaintiff of which is patient after giving full information of the risk involved in the operation. The absence of proper consent also rendered the surgery as a battery, which is a trespass, considered as a trespass. Regarding the criteria of the informed consent with respect to abortion, it is says that it is held in the case of Planned Parenthood of Southeastern Peninsula versus Robert P. Case that Supreme Court held that except in a medical emergency, except in a medical emergency, at least 24 hours before performing an abortion, a physician must inform the woman of the nature of the abortion procedure, the health risk of the abortion and of childbirth, and the probable gestation age of the unborn child. Second, the physician or a qualified non-physician must inform the woman of the availability of printed material published by the state describing the fetus and providing information about medical assistance for childbirth. Information about child support from father and a list of agencies which provide adoption and other services as alternative to adoption. And third, the woman must certify in writing that she has been informed of the availability of these materials. Meaning thereby informed consent is propounded by the American court and it is followed by Canadian court as well, and it is the duty of the doctor to inform the patient all the risk, all these additional information which is required to inform, so that patient can take the decision accordingly, whether he want to submit for the treatment or not. Significance of the informed consent. It says the fundamental principle behind this doctrine is that interference, however slight, with person's body constitute trespass to person. Trespass to person is a wrong under the law of tort, known as a battery, assault, and false imprisonment. The doctrine of informed consent has developed as primary means of protecting a patient's right to control his or her medical treatment. Under this doctrine, no medical procedure may be undertaken without patient consent. Consent must obtain after the patient has been provided with sufficient information to evaluate the risk and the benefit of the proposed treatment and other available options. The doctrine presupposes the patient's capacity to take a decision on the level of treatment, its implication and risk involved, based on his or her understanding of the necessary medical facts provided by the doctor and his or her own personal circumstances. The meaning thereby, if uh, the body of every person is in violate, nobody can violate, trespass his body. If anyone do this, it will be considered as a trespass to person. Uh, and for this, it has been uh, developed, it has been finalized, and it has been propounded that all the related information has to be given to the patient by the doctor. Only then consent should be taken. Meaning and component of informed consent. Informed consent is a process in which a medical practitioner educates a patient about the risks, benefits, and alternatives of a given procedure or intervention. The patient must competent to make a voluntary decision about whether to undergo the said procedure. Informed consent is both an ethical and legal obligation of medical practitioner and originate from the patient's right to direct what happened to his body or her body. It is an obligation of the medical practitioner to make it clear that the patient is participating in the decision making process and avoid making the patient feel forced to agree to with the provider. There are three components of such consent. That is, uh, uh, three components are information, voluntaries, and capacity. This is seen as a more of legal requirement than ethical moral obligation on the part of the doctor towards the patient. Meaning thereby, it is the right of the patient to participate in the decision making in the regarding the medical treatment. Informed consent as a patient's right, as it is recognized as. Informed consent is the legal embodiment of the concept that each individual has a right to make decisions affecting his or her well-being. To do so, decision maker must have knowledge of the risks and potential benefits. In the case of doctor-patient relationship, the onus of the disclosure of the risk lies with the doctor, and the right to decide the manner in which his or her body will be treated lies with the patient. Hence, it is the duty of the doctor to disclose information of the risk involved from the treatment to the patient. There are various issues related to informed consent. Recent year, many action has been brought by the patient who alleged that they did not understand the nature of the medical procedure to which they agree. Number of the cases are there when it is challenged that they were not informed, patients were not informed. So broadly, there are four issues uh, which I have covered. Legal obligation on doctor, therapeutic privilege, failure of doctor, role of hospital. Regarding legal obligation on doctor, it is legal obligation on doctor towards patient that all information must be explained in comprehensive non-medical terms, preferably in local language. Local means the language should be used by the doctor, which is understand, which a patient can understand, and mm, and the doctor will explain about the nature of the illness or diagnosis, nature of the proposed treatment, alternative procedure, risk and benefit involved in both the proposed and alternative procedure, potential risk of refusal to treatment, relative chances of success or failure of both procedure. Yet in practice, this is not always so easy or so simple because in certain situations, the patient may be in dire need of treatment, but revealing the risk involved may, may frighten him to refusal. Therapeutic privilege, it is with the doctor. The doctor, sometime it may happen, the doctor may not reveal the risk involved if patient prefers not to be informed. And when complications are terrible, when revealing complications is likely to have a gross impact on psychology of the patient, meaning that a close relative of the patient can be informed of the complication and a colleague should be consulted, preferably patient's family physician for the treatment of the patient. So this is known as a therapeutic privilege, but the doctor should note his decision and reason for the same in patient's case record. Informed consent is must. Therefore, we can say informed consent is must in all surgeries, administration of anesthesia, and all complicated therapeutic and diagnosis procedure. Meaning thereby, if at any time doctor think it should not be, risk should not be involved because of the several reasons as I discussed, then doctor has to maintain the record in the patient's file. Regarding the failure of doctor, sometimes it happens that physician failure to provide the patient with information necessary to make an informed and intelligible choice. It will be considered as a breach in standard of disclosure, which makes a prima facie case for negligence on the part of physician if found to be cause of the alleged injury. Meaning thereby if physician failed to inform the patient about the and about the disclosure of risk, then it shall be considered as a negligence on the part of doctor. Regarding role of the hospital, it is a very emerging debatable issues. A question, does the hospital have a responsibility to ensure that the patient have received adequate disclosure of risk? Under the theory of respondent superior, an employer, that is hospital, could be held jointly liable with the employee, that is the doctor, whose failure is obtained, whose failure is to obtain informed consent could be shown to have caused injury and damage to a patient. Meaning that for the failure of the doctor, hospital may be held liable on the principle of superior respondent superior. A patient can withdraw his consent after signing a consent. It happens that a patient can withdraw his consent after signing a consent form. Though this is the rule, but there are practical limitations in such cases. If patient is admitted in a hospital, it is the obligation of the hospital to make sure that no member of the hospital staff performed the refused procedure. Yes. Now, regarding the approach of Indian court, in several cases, Indian court find that informed consent is missing there, as in the case of Miss Chennaya versus Sri Gokulam Hospital. In this case, the wife of the complainant, uh, approached the hospital with abdominal pain and was advised to doctor advised to undergo hysterectomy, for which the consent was obtained from the complainant. However, the complainant wife was suffered from bleeding of uterus. As a result, 2 units of blood was transfused after the operation. The blood units so transfused were not tested for contamination. The patient suffered with HIV/AIDS after 3.5 years of the transfusion and died. Transfusion of the blood, and she has died. The hospital was held liable. It was noted that the consent of the patient was required for transfusion of the blood. It was clear from the record that the complainant had given the consent only for the hysterectomy operation, not for the transfusion of the blood. So here the consent of the patient was not there. And next, in the case of Shahai and Pillai versus S. Sharma, in this case, National Commission held that the pursuit of the 8 consent form, which are basically in Malayalam, shows that the Samad hospital had obtained consent from the patient, and mentioning relative of the patient, mentioning that surgery will be performed under anesthesia. There are These are the printed form where certain English words like blood transfusion, ultrasound scan are mentioned. But there is no specific mention about the name of the surgery, which surgery has to be taken place. For example, cervical in or and the size of and the type of anesthesia, namely spinal anesthesia, local anesthesia. It was not mentioned there. Signature were taken from the patient relatives in the mechanical fashion on some of these forms, much in advance of the date scheduled from surgery. Hence, these forms cannot be considered by any stretch of imagination that these were the informed consent. Meaning thereby filling of the forms in much advance of the date of the surgery, it will not be considered as a informed consent where there no proper information is mentioned. And the case of S. Tamil Salvi versus Dr. Surya Kala, in this hospital, Surya Hospital mentioned that we are the hospital who maintain the procedure to inform the patient, and they respect the right of the patient. So many things, but here in the case found that the consent form filled by the husband of the complainant reveals that the procedure surgery to be performed has not been mentioned clearly, understandable in the understandable terms, which is not able to understand. The procedure surgery has not been explained to the patient or guardian in simple, understandable terms in the local language. Many columns are blank. The signature of the husband of the patient has been taken in the column meant for witnesses, which can mean either there was no consent from the patient or guardian, or to be liberal to opposite party, it can mean there were no witness. There was no consent for the blood transfusion, and there was no consent for anesthesia. The party meaning thereby the forms were not complete. It was partly filled. The partly filled up consent form narrated as mentioned just beyond that none of them can be classified as informed consent. This is a clear-cut deficiency of services on the part of this one. In this case, the complainant approached to consumer court. and it was proved by the relative of of the complainant that means consumer means the forms which were given by the hospitals were incomplete, and whatever written it was not understandable terms. Therefore, it says the services granted by this hospital doctor is not uh, adequate services. It is a deficient services. There is a very important case, that is a Samira Kohli versus Dr. Prabha Manchada and Nizam Institute of the Medical Science, where the Supreme Court laid down the guidelines to follow regarding the informed consent. Let us take the Samira Kohli case. Uh, this case we should know in a very detailed manner what happened in this case. Here, this Samira Kohli, appellant, she was unmarried woman, aged 44, visited the clinic of Dr. Prabha Manchanda, and this appellant or Samira complained about the prolonged menstrual bleeding for 9 days. The doctor examined her and advised her to undergo an ultrasound test on the same day. After examining the report, the doctor had a discussion with the Samira and advised her to come on the next day for a laparoscopy test under general anesthesia for making an affirmative diagnosis. And she has given what shall be the expenses for this treatment for this diagnosis test. Accordingly, on the next day, Samira went to doctor's clinic with her mother. On admission, the Samira's signature were taken on the admission and discharge card, and the consent from the hospital admission and medical treatment, and consent for surgery. And here the admission card shows that the admission was for diagnostic and operative laparoscopy. The consent form for surgery filled by Dr. Lata Rangan. She was the assistant to Dr. Prabha, and she described the procedure to be undergone by the Samira as a diagnostic and operative laparoscopy. Lap, Laparotomy may be needed. Thereafter, appellant Nisa Samira was put under general anesthesia and subjected to a laparoscopy examination. When the appellant was still unconscious, Dr. Lata Rangan, who was assisting Dr. Manchanda, came out of the operation theatre and took the consent of Samira Kohli's mother for performing hysterectomy under general anesthesia. Thereafter, Dr. Manchanda performed an abdominal hysterectomy, that is removal of uterus, and bilateral salpingo operectomy, that is the removal of ovaries and fallopian tubes. Miss Savira Kohli, when he come to know about this thing, she left the doctor's clinic without setting the bill. Uh, on 23rd, 1995, on 23rd May 1995, Dr. Manchanda lodged a complaint with the police alleging that the friend, means a friend of Samira, had abused and threatened her, and against medical advice, he got the and her friend got the Samira discharged without clearing the bill. The appellant also, Samira also lodged a complaint against the doctor alleging negligence and unauthorized removal of her reproductive organs. There was some legal notice, and finally on the 19th January 1996, the appellant filed a complaint before the National Commission claiming a compensation of 25 lakh rupees from the doctor respondent. The appellant alleged, Samira alleged that the doctor was negligent in treating her, that the radical surgery by which her uterus, ovaries, and fallopian tubes were removed without her consent when she was under general anesthesia for a laparoscopy test. was unlawful, unauthorized, and unwarranted, that on account of the removal of her reproductive organ, she had suffered premature menopause, necessitating a prolonged medical treatment and a hormone replacement therapy course, apart from making her vulnerable to health problem by way of side effect. The compensation claim was for the loss of reproductive organs, consequential loss of opportunity to become a mother, for diminished matrimonial prospects, for physical injury, resulting in the loss of vital body organs, and irreversible permanent damage, for pain, suffering, emotional stress and trauma, and for declining in the health and increasing vulnerability to health hazard. The medical records and notices exchanged were produced as evidence in the court. After hearing arguments, the commission dismissed the complaint. The commission held that the appellant means Samira, voluntarily visited the respondent clinic for treatment and consented for diagnostic procedure and operative surgery. The secondly, commission held that hysterectomy and other surgical procedures were done with adequate care and caution. And third, the surgical removal of uterus, ovaries, etc., was necessitated as the appellant was found to be suffering from endometriosis, and if they had not been removed, there were likelihood of the lesion extended to the intestine and bladder and damaging them. Feeling, up, feeling aggrieved with this decision, the appellant has filed appeal in the Supreme Court. The Supreme Court observed certain points for consideration. There was following questions arise, that whether informed consent of a patient is necessary for surgical procedure involving removal of a reproductive organ. If so, what is the nature of such consent? Second, when a patient consults a medical practitioner, whether consent given for diagnostic surgery can be constituted as consent for performing additional or further surgical procedure, either as conservative treatment or as a radical treatment, without the specific consent for such additional or further surgery. Whether the third question was to consider whether there was consent by appellant for abdominal hysterectomy and bilateral self-incho-operectomy performed by the respondent, means doctor, whether the doctor had falsely invented a case that appellant was suffering for endometriosis to explain the unauthorized and unwarranted removal of uterus and ovaries, and whether such radical injury or this sorry surgery radical surgery was either to cover up negligence in conducting diagnostic laparoscopy or to claim a higher fee. Even if appellant was suffering from endometriosis, the doctor ought to have resorted to conservative treatment surgery instead of performing radical surgery. Whether the respondent is guilty of tortious act of negligence, battery amounting to deficiency in service, and consequently liable to pay damage to the appellant. These were the questions to consider by the Supreme Court. The consent form for the hospital admission and medical treatment to which the applicant's signature was obtained by the doctor can safely be presumed to constitute the contract between the parties, means doctor and patient, which specifically states it is customary that no substantial procedure are performed upon a patient unless and until he or she has had an opportunity to discuss them with the physician or other health professional to the patient's satisfaction. Second, each patient has a right to consent or to refuse consent to any proposed procedure of the therapeutic course. We therefore hold that in medical law, where a surgeon is consulted by a patient and consent of the patient is taken for diagnostic procedure or surgery, such consent cannot be considered as authorization or permission to perform therapeutic surgery, either conservative or radical. Similarly, where the consent by the patient is for a particular operative surgery, it cannot be treated as consent for an unauthorized additional procedure involving removal of an organ only on the ground that the such removal is beneficial to the patient or is likely to prevent some danger developing in future where there is no imminent danger to the life or health of the patient. The apex court held that the medical text and authorities clearly spelled out that laparotomy is at best the initial step and that is necessary for performing hysterectomy or self-injo-operectomy. Laparotomy by itself is not hysterectomy or self-injo-operectomy, nor does hysterectomy include self-injo-operectomy in the case of a woman who has not attained menopause. Laparotomy does not refer to a surgical removal of any vital or reproductive organs. Laparotomy is usually exploratory, and once the integral organs are exposed and examined and the disease or ailment is diagnosed, the problem may be addressed and fixed during the course of such laparotomy. But laparotomy is never understood as referring to removal of any organ. In medical circle, it is well recognized that a catch-all clause giving the surgeon permissions to do anything necessary does not give Raving authority to remove whatever he fancies may be for the good of the patient. For example, a surgeon cannot construe a consent to terminate a pregnancy as a consent to sterilize the patient. So, Apex Court held that the doctor therefore is required to communicate all inherent and potential hazard of the proposed treatment, the alternative to that treatment, if any, and the likely effect if the patient remain untreated. This stringent standard of disclosure was subject to only two exceptions where there was genuine emergency, that is, the patient was unconscious, and where the information would be harmful to the patient. For example, where it might cause psychological damage or where the patient would become so emotionally distraught as to prevent a rational decision. It, however, appears so. Therefore, it is said the doctor is negligent in this case. Further, Supreme Court observed that we have consciously preferred the real consent concept evolved in Bolam and Sidway in preference to reasonably prudent patient test in Canterbury, having regard to the ground realities in medical and healthcare in India. So this is the case where it is mentioned doctor has to take consent for all the procedure or the treatment and the risk involved there. If consent is taken for a particular procedure, only that procedure should have been conducted. As in the case of Nizam versus Institute of Medical Science, in this case, what happened? Here, the patient gave consent for excision biopsy and the cardiac surgeon carried out the operation for complete excision of the tumor and thereby caused damage to the nervous system, resulting in complete paralysis of the lower limb of the patient and other associated complications. Means the consent was given only for the excision biopsy. And the hospital withheld the production of the documents of consent given by the patient before the operation. Supreme Court held consent given by the patient for the excision of the biopsy cannot be interference be taken as an implied consent for surgery of excision of tumor. Consent was given for the excision of the biopsy, but the tumor has been removed, which resulted in the paralysis of the lower limbs of the patient. Supreme Court laid down several guidelines for obtaining the consent before surgical operation or procedure as doctor must seek and secure the real and valid consent of the patient before commencing treatment including surgery. The consent will be real and valid if the patient has the capacity and competency to give consent. Second, if consent is voluntary and if he gives consent on the basis of adequate information about the nature and procedure of treatment. Second, the adequate information furnished by the doctor, any member of his or any member of his team should enable the patient to make a balanced decision. Whether he should submit for the particular treatment or not. The doctor must disclose number one, nature of the proposed treatment or procedure, its purpose, benefit and effects. Number two, its alternative procedure if available. Number C, an outline of the substantial risk and, and next, the adverse consequence of the refusing treatment. These there are four points to be disclosed by the doctor. The consent given only for the diagnostic procedure cannot be considered as consent for therapeutic treatment. Similarly, consent given for a specific treatment procedure will not be valid for conducting some other treatment procedure. The unauthorized additional surgery is necessary only to save life of the patient, and it would be unreasonable to delay such unauthorized procedure until the patient regain the consciousness and take decision. Fourth, there can be common consent for diagnostic and operative procedure where they are contemplated. There can also be common consent for a particular surgical procedure and an additional for further procedure that may become necessary during the course of surgery. The nature and extent of the information to be furnished by the doctor to the patient to secure the consent need not be of stringent and high degree, but should be to the extent which is accepted as normal and proper by a body of medical men skilled and experienced in a particular field. Meaning thereby now this informed consent uh, is a important issue during the medical treatment. It is the duty of the doctor towards patient to inform the patient about all the risk, all the associated risk to be involved in a particular treatment. And second, doctor must take consent if for a particular procedure. If doctor takes the consent of particular procedure, he should treat it like that only. Doctor must respect this right of the patient. This consent should not be treated for the operation of the other for the means the another surgery. Although at a time common consent may be taken. If consent is not taken, then doctor must respect the right of the patient. If doctor fails to do, if hospital fails to do, then doctor shall be liable, hospital shall be liable for the negligence. And informed consent is the extended form of the express consent. It should be written when it may be on the printed form of the consent form, but all the forms should be clear in the terms, and it should be understandable by the patient, and it should be in the language in which the patient understands. So this is all about informed consent. The next topic for discussion is the error of judgment and gross negligence. So we have discussed about the introduction of the informed consent, its background, several approaches, significance of the informed consent, and meaning of the informed consent, the component, and the several case laws, several issues which emerged, and the guide and the, regarding the Indian approach of Indian judiciary, laid down several guidelines uh, to follow and directions to the hospitals or doctors to follow. Thank you for watching me.